Today we're going to tackle the sale of goods. Sale of goods is one of the newly introduced topics. Sale of goods, negotiable instruments, cooperatives, and love torts. So today we're doing one of them, which is sale of goods. Remember, sale of goods stems out of the love contract. We're doing this because of one simple thing. All of us buy things every day. We buy things in shops every day, and it's one of the contracts that we form. So we're doing what we do every day, which is called sale of goods. You look at one simple thing, that for this area, I try to put sections in. But I do not want you, when you're answering, to have this done, because you might forget the sections and the examiner will cross you. So it will be better if you say the Sale of Goods Act, not the section. But just put the sections for a few things. Anyway, let's begin. The contract of sale. The sale of goods is governed by the Sale of Goods Act. It is called the Sale of Goods Act. And the Sale of Goods Act defines or describes the contract of sale in the following terms. It is a contract of sale where the seller transfers or agrees to transfer the property in the goods to the buyer for a money consideration called the price. So you go to a shop, the shopkeeper agrees to give you the item that you want, but at a cost. That cost is called the price. That is what they call the consideration. So if you look at the your love contract, formation of a contract, consideration is one of the major parts. The moment there's no consideration, there's no contract. So, section 3, clause 4, where the transfer of property is to take place after the contract is concluded, or subject to some conditions to be fulfilled, the contract is called an agreement to sell. We may say, if you've planted an acre of maize, and I come to you and tell you, how much is your maize going to sell? Then you tell me it will be this amount. Then I will tell you, okay, the moment it matures, you come and you pick that money. Now that is a contract. It is a contract or an agreement to sell. We have agreed. It's not that it is complete. We've just agreed that it will be there. So that is what we will call a contract in future. It is not done now. It must be noted that a contract of sale is a contract like any other, and that the general rules relating to contract formation in general apply to sales contracts as well. That is what I told you. It has to be the contract. It is supposed to be under the contract, the law of contract. However, special legal rules apply to sale contracts. These are, this is one of the most important things in your exams. The transfer in the property, in the goods. That is the most important thing. The contract must involve the transfer of property in the goods, and in other words, the contract must transfer title and ownership thereof of the goods. Thus, hire purchase agreements are not included. These are lease agreements with an option to buy. Now, let's go slow. When they say the transfer in the property in the goods or title or ownership, you will buy under the Sale of Goods Act. It says transfer of title in the goods passes with risk. That is one thing you must know. Possession of the goods per se does not mean transfer has passed. For example, I will go to Owino or go to Chikubo to buy eggs, and I buy 100 trays of eggs. And I tell them to bring them to my shop in Bokoto. But I've paid for the eggs. Now, most people will think the eggs are mine because I paid for them. Please. The person still owning them or having them is the owner of the eggs. The title in the eggs has not moved. It has not moved. The question is, who has the risk? Now, the moment the person is bringing the eggs from Chikubo to my shop in Bokoto, and unfortunately, they get an accident in Wandegear and the eggs break, do not expect me to allow broken eggs. So at that level, title has not moved. The risk and the title is still with you. Until you transfer the risk to me, that is the only way the title in the goods has moved. The title and ownership of the goods has moved. So you have to be very, very careful. I don't want the examiner to confuse you. Always ask yourself, has the risk moved from one party to the other? The same thing happens if I move to a shop and I wanted to buy glasses. Then I enter the shop and ask the shop owner or shopkeeper that give me that glass. How much is it? He tells me it's 50,000. I'm saying, fine, it's okay. You first give it to me, I look at it. As he goes up to pick it, it breaks. Will it be me to pay for it? Automatically, no. It will be his business because the title in the goods has not moved. But it will be totally different if he gives me the glass, I pay him the money, and as I'm walking out of his shop, the glass breaks. Please, it is not his, it is mine. The risk is now with me. So you have to be very, very careful. So in Robinson versus Graves, G commissioned R to paint a portrait, and R supplied the canvas and other materials. The court held that this was a contract for work, materials, and not a sale of goods. You have to be very careful. You are people going to do, you are an artist, and you request, I've seen guys online saying they want to show how the houses are being done, painted, but they want to use Peacock. And Peacock is willing to bring the paint. But unfortunately, do you want to tell me that that is the contract of sale? No. Peacock is telling the artist that please, you're marketing our product, period. Then we look at the case in Beecham Foods Limited versus North Supplies Limited. A price list of Lucozade drink showed the price as 2 shillings 20 over dents plus 3 dents on the bottle. The court held that goods were the drinks themselves, whereas the bottles had been merely hired. So the moment you buy, the guys who drink soda in glass bottles, the moment you drink the soda in the glass bottle, you always leave the glass bottle behind. Because whatever you paid for is the drink, the soda, not the bottle. Just like guys who drink beer. You drink the beer in the bar, but you will not walk out with the bottle. Because what you've only paid for is the drink, not the bottle. So they're still telling you the consideration must be monetary, money consideration, well. And the goods which form the subject matter of sale must be movable goods. Now, this is one thing that I want to tell you. Under the Sale of Goods Act, they say goods under the Sale of Goods must be movable goods. So land is not a good under the Sale of Goods Act because it is not movable. You cannot tell me that you pick land that is in Kampala and you take it to Mbale. No. That is why land is not a good. Most people always say, the Baganda have a saying, it's Chibataka. And I've always asked them one simple question. Ettaka baliba. Land is not stolen. Tebaliba. The only thing that changes is the ownership of the land. It only changes there. That one you concede. But stealing land, please no. Because theft per se has an ingredient of asportation, meaning it has to be moved from one place to another. Land cannot be moved from there to here, no. It only changes the ownership. So formalities of the contract of sale. The contract of sale is formed under the ordinary rules of contract formation, i.e., offer, acceptance, consideration. As far as capacity is concerned, Section 4.1 provides that capacity to contract is governed by the general rules of contract law. So in other words, when you look at the general rules of contract law, a child below the age of 18 has no contractual capacity. A mad person has no contractual capacity. A drunkard does not have contractual capacity, but they have voidable contracts. So if a child came to pick something and it seems it is going to be of an education nature to the child, or it is a necessity to the child, please, that is a binding contract. It is binding. Even if it is a mad person, a bankrupt person, or an insane person, these contracts are binding. Form of the contract. Generally, as is the case at common law, oral contracts can be enforced. However, under Section 6, a contract of sale of goods of value of 200 shillings and above is not enforceable by action, i.e. court action, unless the buyer accepts the goods sold and actually receives them or gives something in earnest to bind the contract, or in part payment, or unless some note of memorandum is made and signed by the party to be charged or his agent in that behalf. Now, Section 6 of the Sale of Goods Act provides that every contract of sale that is above 200 shillings must be in writing. It must be in writing. I remember this was one of our questions at university during our coursework. Does it make any sense? You are going to buy tomatoes of 500 shillings. It is already above 200 shillings. What happens? You need a receipt because it must be in writing. So is there an advantage of that? But they're also telling you that the moment you do not write, you can either do something that shows that the contract is binding by paying the money. So you've written off the writing. 2, it can be oral. Okay? Because basically contracts, the general rule under contracts is that they're either in oral or in writing. So it is not in writing, but you've done something. You paid. Let me say they've told you it's 500, you give the person 200 shillings, but they will still expect the 300 shillings. That is part payment. So you've done something that there is a binding contract. Then subject matter to the contract. The subject matter of the contract is goods. That is one thing you must know. It is that the goods. We're not going to discuss anything. We're discussing goods. I don't want to be obscene, and do not treat me as obscene. But I just want to make a student understand. If a man walks to a prostitute or to a brothel, he's going to pay money for sex. What is the subject matter? It is the sex. That is what he's paying for. He's not paying for anything else. He's not going to pay for the costume of the woman. Neither is he paying for the scent. No. He's paying for the sex. That is the subject matter of the contract. So the moment I come to a shop and I want a shirt, don't give me a dress, because the subject matter is a shirt. So all chattel personnel other than things in action and money, and all embellments and industrial crops and things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. They're trying to tell you that what makes goods under the sale of goods? When plants or industrial crops, or some of these paintings generally are goods. That is what section 2 is trying to tell you. They are goods. When they say severed of the land, means you can basically remove them off the land. But a house or a building is not a good, because you cannot sever it off the land. You cannot carry a building from Kampala and take it to Bali. No. But you can cut maize from your garden in Kampala, leave the garden uninterrupted, and take it to Bali. Normally, that is what the section is defining. So types of goods. So under section 7, we have two types: existing goods and future goods. Existing goods and future goods. So under existing goods, we still have specific or ascertained and unascertained goods. Now, let me go slow on this. There is what we call specific or ascertained goods. You go to a shop and you ask the shopkeeper that how much is that bag? And the shopkeeper tells you it is 20,000 shillings or 50,000 shillings. You give him the money and he goes away. The moment you're pointing at that bag, it means that is a specific or ascertained good. You've specifically seen it and ascertained it. Then we have what we call an unascertained goods. Some of you guys who have people that you buy things from, you go to what is this place called? I wanted to give a name that is very consonant with you on Karl Marx. What is that housing on gold? What is? Kutos. Kutos. You want clothes from Kutos. And you tell the guys for Kutos that I will need the blue shirts, I will need a black jean, I will need some sneaks of this kind. You've not ascertained them, but you're only telling him something. Then he tells you, okay, these jeans will go for this, the shoes will go for this, all this will go for this, and you pay. But you've paid for something you've not seen. That is what they call unascertained goods. So that we're here was looking at it. The next is future goods. We've been explaining existing goods. Now we're looking at future goods. This includes goods that are not in existence, e.g. crops to be grown or goods to be manufactured. It also means goods that are in existence, but the seller is yet to own them. Future goods cannot be specific goods. All right. You go to roofings and you need a specific type of iron sheets. And they tell you, yes, the iron sheets can be there, but we don't have them now. We shall produce them in October. Then you pay the money. So whatever you're paying for are future goods. Because they're not manufactured at that time. They're not there. I'm not going to keep explaining some of the things because it will be wasting your... Okay, transfer of property. The separation of property and goods is the origin of the Sale of Goods Act. Importance of the transfer of property. In case of goods are destroyed, it is necessary to know which party bears the loss. Why I was telling you, the transfer of the property bears with the risk. So that is what they call the loss. So in case of bankruptcy of either the buyer or the seller, it is necessary to know whether the goods belong to the trustee in bankruptcy. So you have to be very careful. So under section 13, where the property has passed, the breach of any condition on the part of the seller can only be a breach of warranty. The buyer cannot reject the goods for the obvious reason he is now deemed to own them. In other words, you give me, I come to your shop and I want an iPhone Max Pro, and you give it to me. I ask you the price, you tell me the price, and I pay for it. You give me a receipt, and I move away. Please, please. The act says, it says you are in possession of the goods and the title in the goods has passed to you. You can now... The only thing you can reject, because it will not be a condition. Watch your notes, watch on your notes on contracts, the law of contract, and you'll see the difference between a warranty and a condition. A condition means it is a major term, it is a breach in a major term of a contract, and once that breach is noticed by the other party, automatically the contract fails. automatically the contract fails. And I remember giving you this example. At the moment you go to buy a car, and they only give you God, what is happening? My audio is okay. Let me finish this. I was still telling you that you buy a car and your car does not have a side mirror or a single wheel cap, you cannot refuse to take that car because that is just a warranty. It is not a major term of the contract. Because a condition is a major term of the contract and the other party automatically pulls out of the contract. But a warranty is a minor term. Now, the party at breach is asked to pay damages to cover up that mess. Now, at the moment, if you give me the Pro Max iPhone and I moved with it, the moment it is me who has moved with it, please, I cannot reject it. But I will sue you for the price of the iPhone. If I gave you 15 million, I will tell you, please, the phone you gave me is not worth 15 million shillings. So please give me back my money. That is what they're trying to mean. Legal rules relating to transfer of property. I want you to be very, very careful. Some of these things are going to help you in your exams. I've told you these are contained in section 18 to 22 of the Sale of Goods Act. Property in unascertain goods. Under section 18, no property can pass unless and until the goods are ascertained. Now, that is one thing you must know. Even if you paid for the goods that have not been manufactured, or you've not ascertained that I will need this or that, please, the property cannot move. You cannot say that, this bag is for so and so, yet it is not here. That is not there. So property in certain goods under section 19, where the contract is for a certain or specific goods, the property is transferred at such time as the parties intend the property to be transferred. And section 19 sheds some light on this by providing that for ascertaining the intention of the parties, regard shall be had to the terms of the contract, the conduct of the parties, and the circumstances of the case. So, if I came to your shop and genuinely I looked at the bag and I ascertained it and I want it and I've paid for it, the moment I pay for it, the property in the goods is going to be moved the moment you give me the bag. Or the moment you tell me, you go home, I'm going to bring the bag to you. There is something that shows that it has already moved. So the moment it has any problem, please, I will still hold you liable until I receive it. That is when the property in the goods has moved. But before I receive it, it has not moved. Because the risk is still with you. In the event a contrary intention does not appear, section 20 provides the rules for ascertaining the intention of the parties. Where the contract is unconditional and the goods are specific goods, property passes when the contract is made. It is true. Where the contract for the sale of specific goods and the seller is bound to do something to the goods for the purpose of putting them into a deliverable state, property does not pass until that thing is done and the buyer has noticed thereof. It's the same thing I've been telling you. I'll bring the goods to you. Until you bring the goods, that is when the property in the goods will move. But before I bring the goods to you, please, the property in the goods has not moved. So where the goods are in a deliverable state, but the seller is bound to weigh, measure, test, or do such other things as may be necessary to ascertain the price, the property does not move until such things is done and the buyer has notice thereof. You will bring the goods to me, but I have to weigh them. I've bought 1,000 kilos of G-nuts, but you deliver the G-nuts to me. And you tell me every bag is 100 kilos. I have to begin weighing the bags. The moment the bags meet the standard, it is true, that is when I'll take the goods. At that level, the property in the goods has moved to me. Because the weighing is one of the. There is measuring, there is testing. You tell me that you're giving me mercury. I cannot test the genuinity of the material by my mere eyes. I have to take it to the laboratory. The moment I test it in the laboratory and it is true, automatically then it will make sense. But if it doesn't, I'll reject. So when goods are delivered on arrival or on sale or return, property passes when it signifies his acceptance of this to the seller or does anything consistent with adopting the transaction. So the moment the buyer accepts the goods or pays for the goods or does something that makes the seller believe that he has the title in the goods has moved. Then where the buyer fails to signify his approval or acceptance to the seller, but retains the goods without giving notice of rejection, then if show something me I want to do. And fix. What is happening with okay? Where the buyer fails to signify his approval or acceptance to the seller, but retains the goods without giving notice of rejection. Then if a time has been fixed for the return of the goods, or if no time has been fixed on the expiry of reasonable time. For example, I bring my bags of G-nuts to you. You do not approve them, neither do you reject. but you retain the GNATs. And you tell me, now, you have a choice to send the GNATs back to me in a reasonable time. But do not stay with those GNATs for 1 month and they begin developing molds. And you tell me, I do not want your GNATs anymore. Please. That is beyond the reasonable time. Because we have not mentioned anything. Them back in 20 hours. But you've stayed with them, please. Bring them back in a reasonable period. But the moment it exceeds, please, you still have the goods are yours. Where there is a contract for sale of unascertained or future goods by description, and goods of that description is in a deliverable state and unconditionally appropriated to the contract, property passes upon appropriation, and where the seller delivers goods to a carrier to deliver the goods and does not reserve the right to dispose the goods, then the goods are appropriated. Now, when they say, when you look at your sale of goods, there is what we call, when we look at the law of contract, we have a provision of what we will call sell by sample or sell by description. Now, sell by description means the moment there is a sell by description, all the goods must conform to the description, because these are unascertained goods. They must conform to the description. But if it is a sell by sample, then the majority of the goods must conform to the sample. That's one thing you must know. Sell by description, all the goods must correspond to the description. Sell by sample, the majority of the goods must correspond with the sample. I don't want the examiner to always fix you on that. Reservation of title. In some cases, a seller can reserve title to the goods. Section 21 allows a seller, by the terms of the contract, to reserve his right of disposal until certain conditions are met. In this case, the property in the goods does not pass until such conditions are met. Such clauses are generally known as Romafa clauses, after a famous case of Aluminium Industry versus Romafa Aluminium Limited, in which case the plaintiff applied aluminium while reserving title to the goods until full payment had been made. The defendant went into receivership. The English Court of Appeal allowed the plaintiff's claim for the value of the unprocessed aluminium and the proceeds of all the unprocessed aluminium held by the receiver. I know you're going to watch in Kenya, the Romafa case was I was still telling you, in the Kenyan case of Hodges East African Limited versus Kisumu Cotton Mills Limited. In this case, the plaintiff supplied stock items to the defendant with a reservation of a title clause, Ramafa clause, including in the sales invoice as one. I want you to guys to be very careful because we all do these businesses. Now, the moments where you put a clause in a contract which is going to save you. So the defendant went into receivership and the value of the unpaid goods was 500,000 Kenyan shillings. And the total indebtedness exceeded 2 million Kenyan shillings. The court held this clause effective and the receiver could not sell the goods to recover the money owed to the creditor. The property in the goods effectively remained with the seller. I don't want you to be thugs, and neither do I want to teach you thuggery. But there are things that some people do that protect them. I'll sell you the goods, but I will say that the moment you become bankrupt, the goods automatically revert to me until you fully pay for the goods. Now, this is one thing that at times lawyers do in some contracts. You sell land to somebody and you tell him that this a client will come to you and they will want something. Let me say there's land. You have this land, somebody has this land. It is worth 50 million shillings. And you're like, okay, if it is 50 million shillings, but he's your client. Then the other person comes in and wants to buy the land, but he has only 20 million shillings. Then you're like, fine, you can deposit on the land. There's no problem. Now, the next thing is, when are you bringing the balance? The moment you say you bring the balance in 1 month's time, the moment you fail to bring the balance in 1 month's time, there will be a clause to say that, please, you forfeit the money and the land. Now, that is the Ramafa clause. Because the only period that the land will move to you is when you fully paid for it. So whatever little that you have paid for, regardless of whether it is 45 million shillings and there's a balance of 5 million shillings, you will forfeit it. And you also lose the land. It is one of the ways to make the other party pay. That is why I was telling you, please, I'm not teaching you bad manners. Neither do I want to teach you thuggery. But just know some of the things are legal. But you also have to put one aspect of fairness, equity. Don't just do it for the purposes of benefiting yourself. Have the equity part of it. Okay, risk and the property in the goods. The risk passes prima facie with the property, even if the goods have not been delivered. If the parties intend for the risk to pass at any other time, then the contract must expressly provide for this. In the absence of an express provision, then the contract of the parties may be relevant in evidencing such intentions. So, therefore, risk remains with the seller in cases where there is no reservation of the title clause. So the moment there is no reservation of the title clause, please, the risk remains with the seller at all times. So the moment it has any problem, please, you'll be held liable. Transfer of property, transfer of title. Closely related to transfer of property in the transfer is the transfer of the title. Title simply means the right of the property in the goods. The common law rule that governs the transfer of title is the nemo dat rule, quod non habet. And I want you to know this: one cannot give what he does not possess. That is what the principle of nemo dat. You cannot sell what does not belong to you. So if you do not have the title, you cannot pass on good title. That is a principle in nemo dat. We shall still see it in land. The moment you do not have title, you cannot pass on good title. This general rule is set out in section 2 of that. Okay, subject to provisions of the act where goods are sold let's just accept, because I don't know what is happening to my network today. Let me concede, because today's network is not very friendly, and I do not always want to teach this way. Let me just concede, and we'll have the class next week. Just bear with me, please. Not that I do not want to teach, but I'm seeing it's jumping off and on, off and on. It doesn't make sense. Just bear with me, please.
Hello, sir. Are you going to share these notes in the group, in the class group?
Yes, I'm going to share them.
All right, thank you.
You're welcome. I'm going to share them, don't get worried.